most challenging part of our conversations with potential clients is explaining to them that sometimes they don't have a case, or they don't have the case that they think they have. So for example, oftentimes someone will call and will tell us that they're the victim of harassment, they're the victim of discrimination. Maybe it's on the basis of their race, their gender, or some other protected category. And they'll explain to me why they believe they were discriminated against at work, or why they believe they were harassed at work. And sometimes those people do have cases. They have strong cases, they have evidence, they have compelling evidence that will allow me to tell their story. But sometimes people have no evidence and they don't have strong cases. And those are difficult conversations, because a lot of times a client will tell their story to me, and they're gonna tell me, well, I am a member of this protected category, or I engaged in this protected activity, and therefore the adverse employment action that was taken against me is retaliatory, is discriminatory, was harassing. And it may be the case that that is true, but sometimes the conduct that happened to the client may have been unfair to the client. And what happened in the workplace, and what happens in the workplace every day, is unfair conduct. I'm a lawyer, and my hands are tied by the laws that California and the federal government have put out on anti-discrimination and anti-harassment. Unless the conduct actually falls within the scope of those laws, it's very possible that I can't assist. So for me, a good case, or a strong case, or a case where I can be effective in representation is a case where the conduct the client is describing is actually unlawful conduct.